Good morning, students. Today we will know about the judicial system. We have a common judicial system for the entire country, unlike the American judicial system, where there are separate courts for the center and the states. Our judiciary is independent of the guidance of the legislature and the executive. The high courts, subordinate courts, district courts function under the Supreme Court. The Supreme Court is the highest court of law and its judgment is final. Supreme Court. The Supreme Court came into existence by an Act of Parliament on January 28, 1950. It is in New Delhi. The President appoints the Chief Justice and the other judges of the Supreme Court. Now, at present, there are 31 judges, including the Chief Justice. Now, we will know about the qualifications of a Supreme Court judge. First of all, he should be a citizen of India. He should have served as a High Court judge for at least 5 years or should have been an advocate of the High Court for at least 10 years. See the difference, students. Or he should be distinguished jurist as per the President's opinion. Then, at the age of retirement of the Chief Justice of the Supreme Court is 65 years, or else they can resign earlier also. If the judges are found guilty while discharging their duties, they can be removed from the office by the President on the recommendation from both the houses with a specified majority. After their resignation or retirement, the judges are not supposed to practice before any court, and their salaries and allowances are decided by an act of the Parliament. So now let us know about the functions and powers of the Supreme Court. Original powers, that means resolving the disputes, that means the fights between the union and the states and between the states. Then safeguarding the fundamental rights of the citizens, interpreting the provisions of the constitution and passing on the rights. Next is appellate powers, that means the citizens, any citizen may file case in the Supreme Court against the judgments given in the lower courts. Lower courts means High Court or the civil courts. The Supreme Court may accept such appeals and issue judgments in these matters. The third function is advisory power. That means the Supreme Court may advise the President when he seeks its opinion on important public issues. The President may consult the Supreme Court for advice on matters related to agreements and contracts entered by the governments formed before the implementation of this constitution. Also, in addition to the above mentioned functions, the Supreme Court serves as the court of records, chief advisor to the center and states, and has the power to issue the special rights. Now, let us know about the high courts. The Constitution provides for a high court in every state. Sometimes there is one high court for 2 or more states. The high court consists of Chief Justice and other judges. The number of judges varies from state to state. The qualifications of a high court judge are: he should be a citizen of India, he should have served as a judiciary officer in a judicial office or worked as an advocate of a high court for 10 years. He should be an distinguished jurist as per the opinion of the President. So, where is our high court, students? For us, the high court is in Bengaluru I hope many of us have seen this High Court. The age of retirement of High Court judges is 62, whereas in the Supreme Court, the judge has to get retired after 65 years. However, they can resign earlier here also. If the judges are found guilty while discharging their duties, they can be removed from the office by the President, supported by a specified majority vote of both the houses of the Parliament. We'll know the functions of the High Court. The High Court has power over the whole state, and its functions are: first, the original power to resolve the civil and criminal cases like naval, marital, and contempt of court cases. Second, to admit appeals against the judgments passed by the subordinate courts in civil and criminal cases. Third, to direct transfer of cases from the lower courts to the High Court, then to supervise the working of the subordinate courts, to admit right petitions to safeguard the fundamental rights and other legal rights of the citizens. The subordinate courts. The Conference of Courts that was held in 1948 urged for independence to subordinate courts, and as a result, specifications about the structure and scope of the subordinate courts have been included in the Constitution. Though subordinate courts differ from state to state, their main features remain the same. Courts have been classified into two kinds. They are civil courts and criminal courts. Now, a brief explanation regarding the civil courts. Every district has a civil court. You must have seen, students, and the district judge is its chief judge. Now here the governor appoints the district judge in consultation with the judges of the High Court. The district judge should have served as an advocate in any court of the state for a period of 7 years. The other judges are selected through a competitive examination. Civil courts, what does it do? It settles disputes related to civil matters like property, land, monetary transactions, marriage, divorce, and others. They also hear appeals from lower courts. The district judge exercises control over all the civil courts in the district. These subordinate courts are under the district courts. First, Court of Subordinate Judge, Court of Additional Subordinate Judges, Court of Municipes, and fourth, Court of Additional Municipes. Now we will know about the criminal court. Criminal courts came into existence on 1st April 1974. They are also known as district magistrate courts. They function under the High Court. The highest criminal court at the district level is the Sessions Court. The district judge performs the function of a judge of this court too. The court takes up crimes like murder, robbery, dacoity, etc. And it has the powers to issue death sentences and also life imprisonment sentences. Such sentences will have to be ratified by the High Court. Similarly, an appeal can be made to the High Court against the judgments given by the criminal courts. The other criminal courts functioning under criminal courts are Chief Magistrate Court, First Grade Magistrate Court, Second Grade Magistrate Court, Third Grade Magistrate Court. Both the district and the Sessions Court are one and the same, with the same judge passing judgments in both. When the court takes up a civil matter, it is called district court, and when it takes up a criminal matter, it is called Sessions Court. Now we shall know about the revenue courts. There are revenue courts in every district and they take up cases relating to land tax, land records, etc. Revenue courts comprise the following courts. They are Tahsildar courts, District Subdivisional Officers Court, District Revenue Court or District Magistrate Court, Commissioners Court, Revenue Board. This is the highest court dealing with revenue cases. It has the power to take up appeals against the judgments of the lower revenue courts. The Revenue Secretary is its head and the court functions under the supervision of the High Court. Now we shall know about the People's Court and it is also known as Lok Adalat. In India, the legal procedure is time consuming and expensive. As an alternative, the government has set up other forms of legal institutions which function faster and are less expensive. These institutions came into existence in the year 1985. One of them is Lok Adalat. It takes up cases from parties who mutually agree to settle down the cases amicably. Lok Adalats are established only in some states. They are Gujarat, New Delhi, Karnataka, and a few others. Some judges of the Supreme Courts, social workers, and young law graduates are the founding members of these courts. Cases which have not been disposed of by the other courts or the High Court can be settled by the Lok Adalats. It has three features. First, it lays stress on compromise. It has to get a compromise by both the parties and it is fast and cheap also. Then third, it reduces the judicial burden on other courts. Lok Adalats take up cases relating to vehicle accidents, land possessions, banking, marriage and alimony, laborers' problems, etc. These courts are established by either the district law authority or the taluk law authority. Two mediators will be present here. The judgments given by the Lok Adalats are final and binding on both the parties. An appeal cannot be filed against them. And these judgments enjoy the same respect that judgments of the civil courts do. So, this is all about this lesson, students. Thank you.